RCW 9A.04.080 Limitation of Actions. Prosecutions for criminal offenses shall not be commenced after the periods prescribed in this section. The following offenses may be prosecuted at any time after their commission: murder, homicide by abuse, arson if a death results, vehicular homicide, vehicular assault if a death results, hit and run injury accident if a death results, rape in the first degree, RCW 9A.04.040 if the victim is under the age of 16. Rape in the second degree, RCW 9A.44.050 if the victim is under the age of 16. Rape of a child in the first degree, RCW 9A.44.073. Rape of a child in the second degree, RCW 9A.44.076. Rape of a child in the third degree, RCW 9A.44.079. Sexual misconduct with a minor in the first degree, RCW 9A.44.093. Custodial sexual misconduct in the first degree, RCW 9A.44.160. Child molestation in the first degree, RCW 9A.44.083. Child molestation in the second degree, RCW 9A.44.086. Child molestation in the third degree, RCW 9A.44.089. And sexual exploitation of a minor, RCW 9.68A.040. RCW 9.68A.040. Sexual exploitation of a minor. Elements of crime. Penalty. A person is guilty of sexual exploitation of a minor if the person compels a minor by threat or force to engage in sexually explicit conduct, knowing that such conduct will be photographed or part of a live performance. Aids, invites, employs, authorizes, or causes a minor to engage in sexually explicit conduct, knowing that such conduct will be photographed or part of a live performance. Or, being a parent, legal guardian, or person having custody or control of a minor permits the minor to engage in sexually explicit conduct, knowing that the conduct will be photographed or part of a live performance. Sexual exploitation of a minor is a Class B felony punishable under Chapter 9A.20 RCW. Except as provided in A of this subsection, the following offenses may not be prosecuted more than 20 years after its commission: rape in the first degree, RCW 9A.44.040. Rape in the second degree, RCW 9A.44.050. Or indecent liberties, RCW 9A.44.100. The following offenses may not be prosecuted more than 10 years after its commission: any felony committed by a public officer if the commission is in connection with the duties of his or her office or constitutes a breach of his or her public duty or a violation of the oath of office. Arson if no death results. Rape in the third degree, RCW 9A.44.060. Attempted murder or trafficking under RCW 9A.40.100. A violation of any offense listed in the subsection 1D may be prosecuted up to 10 years after its commission, or, if committed against a victim under the age of 18, up to the victim's 30th birthday, whichever is later. RCW 9.68A.100. Commercial sexual abuse of a minor. Penalties. Consent of minor does not constitute defense. A person is guilty of commercial sexual abuse of a minor if he or she provides anything of value to a minor or a third person as compensation for a minor having engaged in sexual conduct with him or her. He or she provides or agrees to provide anything of value to a minor or a third person pursuant to an understanding that in return, therefore, such minor will engage in sexual conduct with him or her. Or he or she solicits, offers, or requests to engage in sexual conduct with a minor in return for anything of value. Commercial sexual abuse of a minor is a Class B felony punishable under Chapter 9A.20 RCW. In addition to any other penalty provided under Chapter 9A.20 RCW, a person guilty of commercial sexual abuse of a minor is subject to the provisions under RCW 9A.88.080 9A.04.080 and 9A.88.140. Consent of a minor to the sexual conduct does not constitute a defense to any offense listed in this section. For purposes of this section, sexual conduct means sexual intercourse or sexual contact, both as defined in Chapter 9A.44 RCW. RCW 9.68A.101. Promoting commercial sexual abuse of a minor. Penalty. Consent of minor does not constitute defense. A person is guilty of promoting commercial sexual abuse of a minor if he or she knowingly advances commercial sexual abuse or a sexually explicit act of a minor, or profits from a minor engaged in sexual conduct or a sexually explicit act. Promoting commercial sexual abuse of a minor is a Class A felony. For the purposes of this section, a person advances commercial sexual abuse of a minor if acting other than as a minor receiving compensation for personally rendered sexual conduct, or as a person engaged in commercial sexual abuse of a minor, he or she causes or aids a person to commit or engage in commercial sexual abuse of a minor, procures or solicits customers for commercial sexual abuse of a minor, provides persons or premises for the purposes of engaging in commercial sexual abuse of a minor, operates or assists in the operation of a house or enterprise for the purposes of engaging in commercial sexual abuse of a minor, or engages in any other conduct designed to institute, aid, cause, assist, or facilitate an act or enterprise of commercial sexual abuse of a minor. A person profits from commercial sexual abuse of a minor if, acting other than as minor receiving compensation for personally rendered sexual conduct, he or she accepts or receives money or anything of value pursuant to an agreement or understanding with any person whereby he or she participates or will participate in the proceeds of commercial sexual abuse of a minor. A person advances a sexually explicit act of a minor if he or she aids or causes a sexually explicit act of a minor, procures or solicits customers for a sexually explicit act of a minor, provides persons or premises for the purposes of a sexually explicit act of a minor, or engages in any other conduct designed to institute, aid, cause, assist, or facilitate a sexually explicit act of a minor. A sexually explicit act is a public, private, or live photographed, recorded, or videotaped act or show intended to arouse or satisfy the sexual desires or appeal to the prurient interests of patrons, and for which anything of value is given or received. A patron is a person who provides or agrees to provide anything of value to another person as compensation for a sexually explicit act of a minor, or who solicits or requests a sexually explicit act of a minor in return for a fee. Consent of a minor to the sexually explicit act or sexual conduct does not constitute a defense to any offense listed in this section. For purposes of this section, sexual conduct means sexual intercourse or sexual contact, both as defined in Chapter 9A.44 RCW. RCW 9.68A.102. Promoting travel for commercial sexual abuse of a minor. Penalty. Consent of minor does not constitute defense. A person commits the offense of promoting travel for commercial sexual abuse of a minor if he or she knowingly sells or offers to sell travel services that include or facilitate travel for the purpose of engaging in what would be commercial sexual abuse of a minor, or promoting commercial sexual abuse of a minor if occurring in this state. Promoting travel for commercial sexual abuse of a minor is a Class C felony. Consent of a minor to the travel for commercial sexual abuse or the sexually explicit act or sexual conduct itself does not constitute a defense to any offense listed in this section. For purposes of this section, travel services has the same meaning as defined in RCW 19.138.021, RCW 9A.64.020, incest. The following offenses may not be prosecuted more than 6 years after its commission or discovery, whichever occurs later. Violations of RCW 9A.82.060 or 9A.82.080. Any felony violation of Chapter 9A.83 RCW. Any felony violation of Chapter 9.35 RCW. Theft in the first or second degree under Chapter 9A.04.080 RCW when accomplished by color or aid of deception. Theft from a vulnerable adult under RCW 9A.04.6.400. Trafficking in stolen property in the first or second degree under Chapter 9A.82 RCW in which the stolen property is a motor vehicle or major component part of a motor vehicle as defined in RCW 46.80.010. RCW 46.80.010. Definitions. Major component part includes at least each of the following vehicle parts: engine and short blocks, frame, transmission and or transfer case, cab, door, front or rear differential, front or rear clip, quarter panel, truck bed or box, seat, hood, bumper, fender, and airbag. The director may supplement this list by rule. The following offenses may not be prosecuted more than 5 years after its commission. Any Class C felony under Chapter 74.09 or 82.38 RCW. Bigamy may not be prosecuted more than 3 years after the time specified in RCW 9A.64.010. The following offenses may not be prosecuted more than 5 years after its commission. Any Class C felony under Chapter 74.09, 82.36, or 82.38 RCW. Bigamy may not be prosecuted more than 3 years after the time specified in RCW 9A.64.010. A violation of RCW 9A.56.030 may not be prosecuted more than 3 years after the discovery of the offense when the victim is a tax-exempt corporation under 26 U.S.C. Section 501c3. No other felony may be prosecuted more than 3 years after its commission, except that in a prosecution under RCW 9A.44.115, if the person who was viewed, photographed, or filmed did not realize at the time that he or she was being viewed, photographed, or filmed, the prosecution must be commenced within 2 years of the time the person who was viewed or in the photograph or film first learns that he or she was viewed, photographed, or filmed. No gross misdemeanor may be prosecuted more than 2 years after its commission. No misdemeanor may be prosecuted more than 1 year after its commission. The periods of limitation prescribed in subsection 1 of this section do not run during any time when the person charged is not usually and publicly resident within this state. In any prosecution for a sex offense as defined in RCW 9.94A.030, the periods of limitation prescribed in subsection 1 of this section run from the date of commission or 2 years from the date on which the identity of the suspect is conclusively established by deoxyribonucleic acid testing or by photograph as defined in RCW 9.68A.011, whichever is later. If, before the end of a period of limitation prescribed in subsection 1 of this section, an indictment has been found or a complaint or an information has been filed, and the indictment, complaint, or information is set aside, then the period of limitation is extended by a period equal to the length of time from the finding or filing to the setting aside.